Thank you very much for joining this third of our three-part webinar series on the illegal migration bill. Almost a year to the week of our presentation on the Nationality and Borders Bill, and who knows what 2024 will bring. This bill certainly reaches new and quite astounding lows. My name is Nicola Braganza, and I'm a member of the Immigration, Public Law, Discrimination and Children's Rights teams at Garden Court Chambers, and I am chairing this evening's webinar. Before I introduce our other speakers, by way of housekeeping, as I've mentioned, the webinar is recorded and we may disseminate it more widely. The slides are available and will be sent out after this evening's webinar, and I know that the slides from the last two evenings are available on our website, as are the links to the recorded sessions. And if you have any questions, please put those in the chat box and we will try to answer those at the end of our presentations. So now to the speakers. I'm delighted to be joined by all our experts. First of all, we have Kate Aubrey-Johnson, a youth justice specialist barrister and mediator with experience as a criminal defence practitioner and public lawyer. And Kate will briefly speak about our children's rights team. We then have Ollie Persey speaking about age assessments. Ollie is a public law and human rights expert specialising in representing children and young people. Ollie's ranked by the Legal 500 as a Tier 1 rising star in administrative and human rights law, community care, court of protection and education law. We then have Kathryn Cronin, who has extensive experience and a varied immigration, asylum, family law practice with expert knowledge of the intersection between family law and immigration law. And Kathryn will speak to the Home Office's provision of accommodation and other support and the cancellation of the looked after status. I will then speak briefly about detention and removal of unaccompanied children, and then I will be followed by Amanda Weston, KC, who will speak to children's loss of residence and citizenship rights. Amanda is a leading public and administrative law silk. She co-authors Judicial Review, a Practical Guide. She's a member of the A-Panel Council for the Equality and Human Rights Commission, and she has extensive experience in cases in the family division, administrative court and appeal courts, where the rights of children and young people are in play. So with that, I will hand over to Kate. Thank you, Kate.
Thank you so much, Nicola. Good evening, everyone. I just wanted to take this opportunity, it's the start of our third in this webinar series, which is focusing on children's rights, to just talk about why children's rights are so important to Garden Court Chambers, and we have a specialist team. We want to ensure that every child is represented by a barrister at Garden Court who has specialist knowledge of children's rights. So we'll be running internal as well as external training. We want to shine a spotlight on how legislation, policy and guidance is impacting children. And we hope that alongside some of the fundamental attacks on children's rights, we will also be able to showcase positive developments. We want to offer holistic representation. We're very privileged to have a rich expertise across chambers, and we want to work to provide a multidisciplinary approach in our casework. So we're able to pull in the expertise of people from across chambers and work collaboratively. And we want to be part of developing and strengthening children's rights through litigation, policy work and education, guided by children's lived experience working with grassroots organisations and NGOs. So we're ambitious about the future. I'm really delighted that we're able to share expertise today to a wide audience. So I thank the impressive panel of speakers this evening, Nicola, Ollie, Kathryn and Amanda, for speaking to us this evening. Never has it been more important to have a collaborative approach to protecting and defending children's rights.
Thank you, Kate. And so with that further introduction, Ollie, over to you, please.
Thank you very much, Kate and Nicola. Anusha, if you're able to share my slides, please. thank you so much. So I want you to scroll back 1 year to the Nationalities and Borders Act, NABA, or what we used to call NAB when it was passing through Parliament. And I'm talking about the reforms to age assessments as a background to the reforms that are happening in the new illegal migration bill, because establishing age as a precedent fact determines the level of protection that you get at the moment and in these reforms that are coming in. So next slide, please. So in my 10 minutes or so, I aim to go through what broadly age assessments are. And I'm sorry, most of you know what they are, but I know there's a sort of mixed background of people attending here. So I'll go through that quite quickly. The reforms under the Nationality and Borders Act, or NABA, and why that is important when considering the reforms, particularly the reforms that Kathryn is going to be speaking to in this bill. So next slide, please. So what is an age assessment? Well, in many ways, it does what it says on the tin. It's an assessment of age, and it can be by the Home Office or by a local authority. And very often you have an assessment of age by the Home Office upon arrival, and a claim of asylum by an unaccompanied asylum-seeking child is a very common situation where that arises. If that putative child has been assessed as an adult, a local authority will very often have to do a full assessment, or at least a brief assessment, of that putative child's age. Now, that's really important for the reasons that I list briefly towards the bottom of my slide. Broadly, at the moment, there are some levels of protection in policy against detention and removal, and some protections that Nick Clegg was so proud of that came in the Immigration Act 2014. Establishing that you're a child as a precedent fact is vital as a gateway to getting support under the Children Act. Both in particular looked after child status under Section 20 of the Children Act and accommodation that follows. It's also important to establish age as a precedent fact accurately and precisely for the purposes of education. And the Children and Families Act 2014, which is the Special Educational Needs governing statute, provides that a child or young person goes up to 25. And whether you have a special educational need or not that requires special educational provision is defined relative to your age. So you need an accurate assessment of age if a child or young person has or may have a special educational need that requires special educational provision through an education, health or care plan. It's also not just 18 or under 18, or 25 or under 25. In relation to that's important. It has to be accurate and precise because special educational provision, as I just said, measured relative to your performance of someone of the same age as you. So that has to be accurately based on your age. So you need to know if that person's 15, 14, 12, or 21, 22. It determines how long they're eligible for support for and the extent of the support they require. It's also important in relation to accommodation under Section 20, because the regulations that I put on the screen, I'm not going to read out the long title, basically make it lawful to have unregulated accommodation for 16 and 17-year-olds. So just a sort of ballpark under 18, over 18 may not be good enough in that context, because it makes a difference in terms of safety of the accommodation that's being provided to the child at the moment. Next slide, please. So that should say Section 52. I'll add that when the slide's circulated. But the National Age Assessment Board, Scientific Methods, and the First Year Tribunal Appeals are the three big reforms that are coming in the Nationality and Borders Act, which is in the process of being implemented. So going on to the next slide. Section 50 of NABA, where an age-disputed person is referred to the NAB by a local authority, the NAB, so this new age assessment board, which will be formed by the Home Office as part of the Home Office, consisting of social workers who report to the Home Office, will be binding on both the Home Office in relation to immigration functions and local authorities in determining access to children's services. That's hugely important because going down to the bottom of my screen, the representative body of social workers has expressed grave concerns about institutional pressure on Home Office employed caseworkers to meet immigration-related targets. So a political priority of reducing immigration affecting their independence. The BSAW has suggested that if there is to be such a board, it's much better suited under the purview of the Department for Education, which currently supervises social workers, than the Home Office, where there will be this institutional pressure in relation to immigration targets. I wanted to draw attention to one particular part of Section 50, which is subsection 4, which I think will have relevance to the upcoming bill. So in the upcoming bill, I'm not going to go into it into too much detail because Kathryn will be covering it. There is a power for the Home Secretary to effectively cancel looked after child status, which is an outrageous power, which that power has been exercised for the purpose of removal. So Section 50, subsection 4 provides that basically a local authority has to provide evidence to the Home Office about its age assessment of a child. And if they found that person to be a putative child to be a child, explain the basis for it. Now, I'm worried that that is going to be used as a trigger for local authority, for the Home Office or the Home Secretary to then exercise their power to cancel looked after child status if this person is a 17-year-old or a 16-year-old, whilst the NAAB is being set up. So once the NAAB is at full capacity, its decisions will be binding. It also has the institutional pressure of the Home Office behind it. That's going to be a work in progress, in process of recruiting social workers to work at the NAAB. But whilst that's happening and local authorities are doing more of the heavy lifting on age assessments, I think Section 50, subsection 4 is going to be a sort of tool by which the Home Office is put on notice to exercise its power to cancel looked after child status. Next slide, please. So I briefly want to talk about Section 52, which is the scientific methods, and this is very much a work in progress. So I've extracted recommendations from the Interim Age Assessment Science Advisory Committee, which published its interim recommendations early at the beginning of this year. And essentially, they've given a provisional green light to for what had previously been discredited and controversial and considered to be harmful biological or scientific assessments of age. This is still a work in progress. It's an interim report and very much a watch this space in relation to the recommendations that are coming through. But it's one to keep an eye on the work of the AESAC and expect regulations with more detail to be forthcoming. That's one point I just want to briefly touch upon, is much of the age assessment reforms are upcoming. There will be regulations that need to be made and scrutinised and will be subject to limited scrutiny in Parliament. And any regulation would obviously be potentially judicially reviewable as secondary legislation. The other point I wanted to flag is the issue of consent in relation to scientific methods. And we're waiting the detail, and again, the devil will be in the detail in terms of the content of these regulations, but it's hard to see in the power dynamic of an age assessment of a putative unaccompanied asylum-seeking child, who is going to be able to consent on their behalf to these invasive and controversial procedures, which, as you'll see, recommendation 6 identifies that radiation will be a risk to them. So I think watch this space, and particular scrutiny will be required for regulations made under section 52 of NABA about what they say about the suitability of a person that can purportedly provide consent on behalf of a putative unaccompanied asylum-seeking child who's being age assessed by these invasive techniques. Next slide, please. And I just wanted to flag the appeals process. And on the face of it, taking this out of context, a move from judicial review to an appeal right might be considered to be a good thing, because that will be a substantive appeal by a judge rather than sort of judicial review applying public law principles. However, obviously judicial review in the context of age assessments is slightly different, because you have the initial permission threshold to meet, which is lower in an age assessment judicial review, and then ordinarily transfer to the upper tribunal for a substantive trial. So it's not the big advantage to judicial review that it might be in other settings. And unfortunately, it's become clear that this is going to be in the immigration and asylum chamber rather than the health, education and social care chamber. And this would be much better suited to the HESC, because the way that works, for example, in an education healthcare plan appeal, is that you have a judge, but you have 2 expert panel members, potentially a social worker, someone with expertise in the substantive area, that scrutinise the public authority that's been making the decisions and rigorously assess the evidence and can draw upon their own expertise. That's not going to happen because it's going to be going into the IAC. The fee structure will have cause material problems in terms of access to justice. The legal aid situation will broadly be the same as any other immigration appeal in the first tier tribunal IAC. Apologies, got a bit of a cough in the back of my throat. And we already know that the legal aid provider base is decimated. So the good thing about age assessments at the moment is that there is potential for inter partes cost recovery. So it makes the work financially sustainable for legal aid providers working on very tight margins. Where there's a legal aid crisis, not enough immigration legal aid solicitors who are prepared to work understandably because it's not financially sustainable under the current model. This is just going to exacerbate the immigration legal aid crisis because there will be a huge volume of appeals coming into the first tier tribunal. And I think that's broadly the end of my slides. Could you just click on it, Anisha, please? Yes, thank you. I've flagged where I think there are some issues in how these reforms are going to affect interplay with the reforms that are coming in with the illegal migration bill. I think essentially it's a gatekeeping exercise in relation to establishing someone being a child as a precedent fact. And that the knob taken with the cruelty of scientific methods, and what happens if you refused this assessment? Is there going to be an adverse inference drawn from refusing a potentially harmful, invasive assessment? And then taken with the difficulties in actually holding the decision makers to account because of the access to justice concerns with the first tier tribunal appeal right, that's going to make it harder to establish that you're a child as a precedent fact for public authorities exercising their statutory duties in relation to children and protecting children as children. Thank you very much.
Thank you, Ollie. That was really excellent. Thank you. Kathryn, I think you're next, please.
Yes. Well, I'm not sure if I'm showing up here, but I'll start speaking in any event.
Yeah, it's fine. We can see, Kathryn, we can see you and can see your slides.
Oh, good. I start with this is really about the provisions in clauses 15 to 20, and they essentially undercut an enormous protection that is applied to migrant children under Children Act protections. Now, I start with the definitions because the bill gives a definition of what they term unaccompanied children. I won't repeat that because we'll analyze it on the next slide. But I want it to be contrasted with what is the definition of an unaccompanied asylum seeker child in the immigration rules, which essentially really simply requires that the asylum seeker children are under 18 when their asylum application was submitted, applied for asylum in their own right, and are separated from both parents and not being cared for by an adult who in law or custom has responsibility to do so. If we go to the next slide, what I focus on is just the, can we get the next slide? Anusha. Oh, thanks. So the differences between the two definitions, and one can see immediately that the immigration rules, not known for their necessarily for their concern and care for children, but their definition is definitely directed towards child protection, where this is directed towards child exclusion. So the child is an unaccompanied child only when they're 18, whereas the asylum seeker definition includes young adults who lodged their asylum claim when they're under 18. The asylum seeker children will have applied for asylum. Unaccompanied children may not have sought or seek asylum or indeed any term or form of leave. The asylum seeker child may have leave to remain, for example, a student who then claims asylum. The unaccompanied child either entered without leave or by deception, or is in the UK without leave to enter or remain. And the asylum seeker child is in the UK unaccompanied by both parents and not being cared for by an adult, as I indicated before. And I simply note that that is importantly designed to fit in with private fostering provisions and the supervision protections in the Children Act. So you've got an immigration rule being congruent and accommodating to protections arising under the Children Act. The care status of the unaccompanied child is set at the point of entry. So I take two really very common examples that illustrate the different outcomes you're now going to get by the unaccompanied child, migrant child definition being a point of entry assessment of care, and the UASC is the care in the UK. So if you take a child asylum seeker who arrived unaccompanied, but after arrival joins and is cared for by close relatives in the UK, such a child is not an unaccompanied asylum seeker child because they have carers here, but they may well be an unaccompanied migrant child, and notwithstanding family ties in the UK, is likely to be affected by the unaccompanied child strictures and penalties. And a further anomalous example, which may well be an example that people begin to adopt to bring themselves out of these really rather draconian punitive definition, is a child brought to the UK by a close relative, but abandoned here after entry. I mean, some of these are children brought here by relatives for the purposes of trafficking, so they may not be well motivated, but such a child may become an asylum seeker child, again, because they won't have a carer here, but they're not an unaccompanied migrant child because at the point of entry, they had a relative who had care of the child, although that may be contested on the particular facts of the case. If we go to the next slide. In the asylum seekers' journey is generally relevant to their protection claims, but they're not defined by reference to their journey, where the unaccompanied migrant child's journey and whether their life or liberty was threatened en route is a core defining component. So all practitioners are going to have to spend a great deal more time ascertaining facts about the child's journey as a way of perhaps keeping them out of this awful definition. And then I would simply note, as I said at the beginning, that the asylum seeker definition is directed to child's protection, and that includes particular protections with respect to the processing of their asylum claims, whereas the unaccompanied migrant child definition removes child protections and is directed ultimately to their exclusion. If we go to the next slide, the other matter to have regard to is the links between this definition in this particular immigration bill and the looked after and the Children Act protection. Under the Children Act, for those who aren't sufficiently alert to it, a looked after child is one who's within the area of a local authority and is in need, who requires accommodation because there's no one to be able to assist them to have that accommodation, and the child is in local authority care for more than 24 hours. So again, it's a definition that is directed to having a broad class, again, for the purposes of protection. If one goes to the next slide, the looked after, the Children Act specifies particular duties and services for looked after children, and also those children as they move into young adulthood up to 25. So there's welfare duties. There are certainly accommodation duties, and Ollie has mentioned those in his talk. There's also a specific duty to promote the child's education experience, and those duties have got stronger with rather more recent legislation. And there's also, very importantly, care planning with an assigned personal advisor who is to prepare and keep under review pathway plans and to give various forms of assistance with employment, educational training, which again can extend until 25. And the personal advisor has to make sure that the pathway plan is implemented. And there's quite a deal of litigation within the family jurisdiction, making sure that those duties are fulfilled for those children, because it is understood just how important and how protective those duties are. If we go to the next slide. The bill now, first of all, clause 15 empowers the Secretary of State to provide or arrange accommodation in England for unaccompanied children. The accommodation is sparsely defined as simply accommodation under this section. So there are absolutely no indications of the protection, if any, that is going to be associated with that accommodation, unlike the Children Act. And the 15.3 states that the Secretary of State may provide or arrange other types of support for a child residing in such accommodation, and all of these provisions have effect at all times, again, prior to the passing of the bill from the 7th of March. If we go to the next slide, essentially looking at clause 15, what it would do and may well be intended to do only this, is to validate and continue the commissioned hotel arrangements used by the Home Office from at least, we know, 2021, when we have data to accommodate young and vulnerable children. And I indicate there what are pretty well circulated statistics showing that in the year July 21 to June 22, some 116 children, some young as 11, went missing from those hotels. The statistics make clear that these children being accommodated in hotels, and one rather thinks that this will also be open to them under the bill amendments, are being put in this accommodation that isn't regulated. And of course, under the Children Act, for looked after children to be placed in anything other than regulated accommodation, mostly foster care, when you're 15 and younger, is simply not permitted. Clause 15.2 could, but doesn't define the accommodation. Hopefully, some people will seek to get changes to the clause which gets it closer to the Children Act by requiring it to safeguard the child's welfare and for appropriate to be interpreted to be in accordance with Children Act sections and regulations. The clause should also contain a time limit on how long a child spends in Home Office accommodation. Next slide deals with clauses 16 to 19, and it's clause 16 subsections 5 to 8 that I focus on, because these are where the real mischief lies. What these clauses say is that the Secretary of State may decide that an unaccompanied child being looked after by a local authority is to cease being looked after on a certain date. And on simply making that decision about cessation, the Secretary of State must direct the local authority to cease looking after the child on the transfer date. And then on the cessation of the child's looked after status, the Secretary of State must arrange for the child to reside in accommodation for unaccompanied migrant children from that transfer date. We have the next slide, sorry. Then you've got in clause 17 that the Secretary of State has power to direct a local authority to provide information for the purpose of making a transfer of status decision. That information at least is flagged as information about support or accommodation, or such information as may be specified in regulations. In clause 18, if the local authority doesn't comply, or the Secretary of State is not satisfied with their reply, that you can have the Secretary of State directing their response, and may make an order declaring the authority to be in default, and any directions can be enforced at that stage by mandatory order. Clause 19 provides for the Secretary of State to make these regulations or approximations of them to apply to Wales, Scotland, and Northern Ireland. If we go to the next slide, there are so many concerns that are manifest, particularly from these looked after status refusals. Essentially, it allows the Secretary of State to decide whether a child can continue to be deserving of protection. And the enforcement powers suggest that the Secretary of State anticipates that there will be local authority resistance, particularly for certain vulnerable young people who are going to be affected by this. And that may derive from earlier experience that we had with the early Dublin child JRs before the European Court prevented their removal under that regulation, because you had there similar punitive traumatic removals of children by the Home Office, some of them being strongly resisted by local authority staff. The second thing I note is that the that of course the removal of looked after status is not simply about accommodation, which these clauses would suggest, but is about a loss of the protection that I outlined earlier. And the Act and explanatory statement provide no justification for or purpose to be served by this enhancement of the Secretary of State's powers, or justifying the loss of the protections. If we go to the next slide, just noting there that children can lose a great deal by the cessation decision. Some of them will have established foster family placement. They may have to cease their studies. It will break friendships and their dependence on social work, guidance and assistance. And none of their voices are heard or necessarily considered in the cessation decision making. If we go to the next slide, the point I simply make there is that there is a long history of intersecting cases where you have children in both immigration proceedings or issues concerning children in immigration proceedings and also in the family court. And the family court in particular is really scrupulous about in seeing that their jurisdiction is separate, and they want the demarcation to be clear and to be preserved in all sorts of cases. There's, again, quite a deal of litigation, which various of us have been involved in, where the Secretary of State is trying to really prevail upon the family jurisdiction. And until this, until both the NABA age assessment being taken into the Home Office, a task that has always been seen as within the expertise of the local authority, and this clause, you've had the courts resisting that overreaching by the Secretary of State. The important thing is that the Act and explanatory statement provide no justification for the power or the mandatory enforcement provisions. If we go to, and it is, I know that we've had in our seminars and webinars some discussion of, you know, the capacity to challenge by judicial review or otherwise this overreaching by the Secretary of State. And no doubt these clauses will come under scrutiny for exactly that sort of litigation. But in the next slide is here that one of the factors that I indicate that isn't available broadly and really is only going to be able to used for you know, quite clear and deserving cases, but at least one can ensure that a child has got the protection for the entirety of their minority if a care order is made. And there's a very important, interesting case. My footnotes didn't come through on the slide, but it's J, a child, 2017 EWFC at 44. It's by Mr. Justice Jackson, as he then was. And it is care proceedings where you have two asylum seeker boys aged 9 and 10. And he makes very clear that the court had jurisdiction to make a care order in that case. And he set out in quite some detail the sorts of benefits that arise for such children via a care order rather than the looked after assessment. And it's well worth reading, and it's well worth keeping in mind for some children who are looked after and are at risk of having that status take away or would be badly affected by it, that it may well be sensible to consider at least getting that care order that preserves protections for the terms of the childhood. And because these children are generally placed in foster care, they often set up a permanent and established family life with their foster placement. I think that's all I need to say.
Thank you, Kathryn. It's all incredibly distressing and troubling, and now I'm going to make matters worse by telling you about detention and removal of children. Anusha, could you put my slides up, please? Thank you. Thank you very much. So as I say, I'm going to speak about those parts of the bill that deal with the detention and removal of children, which I have to say, in terms of it being provided for in what is intended to be primary legislation, seems to me a very dark day for where our immigration legislation is now heading. Next slide, please. I mean, generally, going through those parts of the bill, there's certainly a theme that emerges, in my view, of very much the Secretary of State saying, I and my immigration officers can very much do what we want and the courts can no longer interfere. And we are specifically setting out this within the ouster clauses. I've taken at the start the very clear statement made by Suella Braverman in terms of not being able to confirm whether the provisions are compatible with the convention rights. And so I've put beneath that, these are not her words, and I should say all emphasis in the slides are my additions. I implicitly agree I'm acting illegally, but nonetheless, it's all about boats and votes. It's all been, however cruel or unlawful. The rhetoric has been very much towards boats and the stopping the crossing of boats, but in fact, the reach of the bill and what is set out within it goes far beyond that. It is, and we come to that on the next slide, please. And in terms of all those arriving without leave or permission. Yet another bill, a year on from the Nationality and Borders Act, making provision yet again for the removal of those entering or arriving in breach of immigration control, making provision about detention for immigration purposes, making provision about unaccompanied children, victims of slavery or human trafficking, citizenship and inadmissibility. And our previous webinars covered parts of those, and I'm now speaking to the detention, and then Amanda will be speaking about citizenship. Next slide, please. The explanatory notes, and what I've done within the slides is to set out what the various clauses say, refer to the explanatory notes and also the memorandum, the ECHR memorandum, and the extent to which that provides any further detail as to what's intended by the clauses. So on the explanatory notes, they set out that the purpose of the bill is to create a scheme whereby anyone arriving illegally in the UK will be promptly removed. And then the 4 bullet points are to deter illegal entry, to break the business model of the people smugglers and to save lives, promptly remove those with no legal right to remain, and make provision for setting an annual cap. And yet, on a basic review of what the bill sets out, the effect is contrary to that, because in fact it appears to contravene international and domestic law and create a scheme where the most vulnerable in our society are made more vulnerable, exposed to greater exploitation, denied access to the courts, detained on arrival for unlimited periods, treated inhumanely, stripped of safeguards and the most basic human rights protections, refugees, children, victims of trafficking and modern slavery, and those fleeing the most severe human rights violations. So the idea that in fact those 4 bullet points are the purpose of it, in fact they lead to the consequences of punishing and targeting our most vulnerable. Next slide, please. Thank you. So the provisions as to removal are dealt with at clauses 2 to 5, and on detention and bail at clauses 11 to 13. I also refer to the disapplication of the duty to consult the Independent Family Returns Panel. That's at clause 14. And specifically for our purposes, we'll be looking at 3, but 3 is to be read with 2 and the 4 conditions that are set out in 2. So next slide, please. So 2 begins with the duty to make arrangements for removal, which we've heard about in our previous webinars. And in order for the duty to come into play, so the Secretary of State must make arrangements, 4 conditions need to be met. And those 4 conditions are the same when it comes to the power to remove in respect of unaccompanied minors and children. So the first of those conditions are that, and we know the person requires leave but enters without leave, or enters with leave obtained by means which include deception by any person. Person has entered the UK in breach of a deportation order, requires entry clearance but arrives without valid entry clearance, requires not to travel without an electronic travel authorization that is valid but arrives without such an ETA. So that's the first condition. Second condition, next slide, please. The second condition is that this all kicks in from on or after the 7th of March. So the person must have entered or arrived on or after that date. Third condition, please, next slide. The third condition is that the person did not come directly to the UK from a country in which the person's life and liberty were threatened. And there's the refugee definition by reason of their race, religion, nationality, membership of a particular social group or political opinion. And they, for the purposes of subsection 4 and not being taken to have come directly, they've passed through or stopped in another country outside the UK. That's the third. Fourth condition, please, next slide. So the fourth is that the person requires leave to enter or remain and does not have it. Any limited leave to enter or remain given on the immigration rules to a person within section 3.1 unaccompanied children is to be disregarded in determining whether the person meets the condition. And the only circumstances that subsection 1 does not apply to a person who meets the 4 conditions in this section are where section 3.1 applies. So the duty does not apply, but then we go to clause 3, which is the power that then applies. Next slide, please. So once you have the conditions from clause 2, they are then applicable to unaccompanied children, and the power is provided for in clause 3, currently provided for in clause 3.1. The duty does not require the Secretary of State to make arrangements for the removal at a time when the person is an unaccompanied child. And then 2, but the Secretary of State may make arrangements for the removal of a person from the UK at a time when the person is an unaccompanied child. So that is where the powers then derive from. The definition of an unaccompanied child, and we've heard from Kathryn in terms of the definition and the difference in unaccompanied asylum seeker child, is that the 4 conditions are met that I just went through. The child is under 18, and at the relevant time, and relevant time is then defined, whether or not a parent of C who was aged 18 had care of the child. Relevant time means the time of C's entry or arrival in the UK, by virtue of which the duty in section 2.1 would apply in relation to C apart from this section. Next slide, please. Now, the European Convention on Human Rights Memorandum sets out that clause 3, which is the power to remove, is likely to engage Article 8, where an accompanied child is not removed for potentially some years until they turn 18, in which time the unaccompanied child may have built some considerable family and private life, although majority of unaccompanied children who claimed asylum in 2020 are aged 16 or 17. However, the delay will not cause interference, and it will be in accordance with the law, namely the section 55 duty and section 17. So there's nothing there addressing how it is compatible with Article 18 if removal takes place prior to the child turning 18. There's nothing about proportionality set out within the memo there. Next slide, please. In terms of the power to remove, so 2.1 we've heard relates to the duty, the power under 3.2 in relation to a person who meets the 4 conditions, that power is exercised regardless of whether the unaccompanied child has made a protection claim, human rights claim, a claim to be a victim of slavery or victim of human trafficking, and the person makes an application for judicial review in relation to their removal. And the consequences from that are that if the person meets the 4 conditions, in section 2 makes a protection claim or a human rights claim, the Secretary of State must declare that claim inadmissible. Next slide, please. And once it's declared inadmissible, cannot be considered under the immigration rules, and there is no right of appeal. So that applies equally to the unaccompanied child. Next slide, please. Human rights claim is then defined country, a claim that removal of a person from the UK to a country to which the person is a national citizen, or a country or territory in which the person has obtained a passport or other document, refers to a claim that was made on or after the 7th of March and has not been decided. Next slide, please. In terms of removal, under section 2, so the duty, arrangements are to be made as soon as reasonably practicable, or where the person has ceased to be an unaccompanied child. In respect of an unaccompanied child, at the moment, clause 5.2 sets out that the provisions there apply to the power which is provided for under clause, or there it's referred to as section clause 3.2. Next slide, please. And further provisions are set out at clause 5 as to where the unaccompanied child, just as with the adult, where the accompanied child is to be removed to, a country of which that child is a national citizen, where the child has obtained a passport or other document of identity, country or territory in which P is embarked for the United Kingdom, or country or territory to which there's reason to believe P will be admitted. And then 4 to 6 deals with exceptions, and specifically if the child is a national of a country listed in section 80A1 of the Nationality, Immigration, Asylum Act, which concerns safe states, the person may not be removed to a country or territory if they make a protection claim or human rights claim and the Secretary of State considers their exceptional circumstances, and those are defined in clause 5.5. Next slide, please. And then the further procedural provisions at clause 7, very briefly, is that there has to be notice given in writing. Notice has to set out where the individual is to be moved to, the country or territory, and the claim period as defined for the purposes of section 40 in terms of serious harm suspensive claims and factual suspensive claims. Next slide, please. That deals with removal. And then we come to detention. Detention and bail, those provisions are set out within clauses 11 to 13. They apply to the totality of the statutory immigration detention powers. The explanatory statement sets out that they are intended to codify certain common law principles and place emphasis on the Secretary of State's opinion as to whether the time period of detention is reasonable, rather than leaving that determination to the court. And in our previous webinars, I think it was yesterday, Greg O'Kelly set out in more detail the provisions on detention. So they're also, these slides are to be read with those. Essentially, if the immigration officer, Secretary of State, suspects that the person meets the 4 conditions in section 2 of the Illegal Migration to Be Act 2023, pending a decision as to whether the conditions are met. If the IO suspects that the Secretary of State has a duty to make arrangements for the removal, pending as a decision as to whether the duty applies, pending whether leave should be granted, pending the person's removal, the power to detain. Next slide, please. And in terms of unaccompanied children, the explanatory notes set out that the new paragraph enables an unaccompanied child to be either detained pending removal or where an unaccompanied child is temporarily exempt from the duty to remove pending the granting of limited leave, and specifically referenced 8AA of the 71 Act, 65(2), which provides for the giving of limited leave to victims of modern slavery. So how does this sit with our current domestic and international law? Next slide, please. So whilst Section 54A has been disapplied, Section 55 has not been disapplied. I cannot see how the current provisions, as they're set out, have regard to the best interests of the child, and that is protected for and provided by Section 55. Articles 3, 5, and 8, depending on the circumstances, seem to me to be engaged. So what are the circumstances of the detention, the period of detention, the conditions, the individual circumstances and vulnerabilities, disabilities of the child? How are these children going to access help, access legal advice? And I note there, which I haven't included within the slide, that this supposedly has been given some thought. And the answer that is provided within the memo is that, so first of all, it said that given that individuals be able to challenge their detention via habeas corpus, the courts will ensure compliance with Article 5 when determining applications. And then it's set out to the extent that Article 14 taken with Article 5 is engaged, the Home Office considers any difference in treatment is justified by the legitimate policy objectives of the bill. So it's very widely stated there, and the need to use detention powers in order to achieve those objectives. Article 8 and 2 protocol may also be engaged by the detention of children, and that is then justified in this way. The department has considered whether the detention of children and of pregnant women would amount to a breach of Article 3. However, given that family groups will be detained together in appropriate accommodation, pregnant women and unaccompanied children will be detained in appropriate accommodation, and appropriate provision will be made for education and any relevant support needs. The government is satisfied that these provisions are compatible. No further detail on that. And then I've set out in there Article 14, that Article 14, the right not to be discriminated against, taken together with other substantive rights under the convention, that it's recognized that that may also be engaged, but the government considers any age discrimination is limited since accompanied children will be removed with their parents, and it would not be a ground that would require very weighty reasons to justify the difference in treatment. So again, but that is dealing with accompanied children being removed with their parents. No reference to unaccompanied. Next slide, please. And in addition to the Human Rights Convention articles and the breaches that potentially arise with these clauses, there's obviously the UN Convention on the Rights of the Child, and Article 37 specifically sets out that no child shall be subjected to degrading treatment, and no child shall be deprived of his or her liberty unlawfully. Detention shall be in conformity with the law, only a measure of last resort. And then, of course, D, every child deprived of his liberty shall have the right to prompt access to legal or other appropriate assistance. And that has particular resonance when we go then to what's provided in respect of the immigration bail, applying for bail. Next slide, please. In terms of the period for which the individual may be detained, Clause 12 sets out that a person may be detained for such period as in the opinion of the Secretary of State is reasonable and necessary. The explanatory notes say that the effect of this clause is to clarify that it's for the Secretary of State rather than the courts to determine what's a reasonable period. And if the Secretary of State does not consider that the examination, decision, removal, or directions will be carried out, made or given within a reasonable period, the person may be detained for a further period that the Secretary of State considers reasonably necessary. Next slide, please. Now, the intention in respect of Clause 12 is to codify the second and third principles of Hardil Singh, which I've set out there, and I expect that you're highly familiar with. Can you go to the next slide, please? And Also, the explanatory note statement set out that, as well as codifying, the clause overturns the common law principle in A, again emphasising that no longer is it for the court to decide for itself whether there's a reasonable or sufficient prospect of removal within a reasonable period of time. Next slide, please. In terms of bail, a person who's being detained, so applicable to unaccompanied children, must not be granted immigration bail by the first tier tribunal until after the end of the period of 28 days, cannot challenge the decision to detain or refuse bail in any court unless there is bad faith or procedurally defective way that amounts to a fundamental breach of the principles of justice. So an extreme narrowing of the basis on which bail can be sought. It's said that habeas corpus is unaffected, but in fact, habeas corpus goes to the power and whether the power is there to detain. And this, if this bill goes through, the power is provided for within, as set out in clauses 11 to 13. Next slide, please. And then finally, as it's relevant to the treatment of children and families, clause 14 specifically disapplies the duty to consult. It sets out that 54A does not apply where the proposed removal is for the purposes of section 2, the duty, or under 7, the power to remove family members. Does not apply where the proposed detention is under then the relevant provisions of the Immigration Act and section 62 or 2B of the Nationality Immigration Asylum Act. And the explanatory notes say nothing in dealing with this, at paras 95 and 96, providing any reason as to why that is. So on its face, beyond assertions that where the relevant articles may be engaged to the extent that they're qualified rights, that they are that the interference is a proportionate one, no detail of any kind is set out or justification given as to how that in fact is met. So those are my slides on detention and removal. Thank you very much, and I will now pass over to Amanda. Amanda, are you there?
Yes, thanks very much, Nicola. Anusha, could you put my slides up, please? Thanks very much. Thank you. I'm going to take this quite briefly because I'm looking at the time and I know that some of you probably have some questions. So if you could move on, please, to the next slide, Anusha. Okay, so we've already looked at the duty to remove in Nicola's slides. I'm not going to go over it again, obviously, but I just want you to bear it in mind when I'm talking about the impact of coming within the 4 conditions for leave to remain, residence, indefinitely to remain, and also citizenship. And I'm going to be explaining to you that the intention of the residence and citizenship provisions in clauses 29 to 36 of the bill intend to set up a gift which keeps on giving. That's to say, even visited down the generations, if you or your parents have ever at any time come within the 4 conditions, subject to the exceptions that I'm going to take you to, then you will be forever debarred from settlement or from citizenship. And we know already as practitioners how that sets up a time bomb of a disaffected cohort of young people who've done nothing but work hard all their school careers, only to be told that citizenship is outside their grasp, either because of the cost of it or now because of it's intended to impose a statutory bar on those children, not for anything that they've done, but for something their parents may have done. So I'm going to come to the detail of that. Move on to the next slide, please, Anusha. You already looked at that. I won't look at those 4 conditions again. Bear them in mind. Next slide, please. So again, key aim of the bill is to make all forms of irregular migration a barrier to any protection status, and remembering that a child is also a person for the purposes of the duty to remove, also there's a question about whether the power to remove a child, an under 18 in such circumstances, could be exercised compatibly with the Human Rights Convention, because Clause 3 of the bill turns the duty to remove, where the 4 conditions are met, to a power in the case of children. Next slide. So what does the government say about the compatibility of Clause 3, which is the discretion to remove under 18s? And they say that it's compliant. That's their position in their memorandum on compatibility. Whenever we are looking at compliance by reference to ameliorating measures that, or safeguarding measures that the government say in proposing the bill will come into play, will prevent the harshest effects, we have to remember the Home Office's lamentable history and record in ensuring that the ameliorating effects, which are designed to assuage citizens' concerns about the harshness of these measures, that their lamentable record in ensuring that they meet their objective. And that is because, and I think that other speakers have referred to this, there is a problem in handing over responsibility for measures of compassion and care to the Home Office with their immigration targets and their obviously conflicted decision makers, if they are conflicted. Some of them aren't very conflicted at all, but that's not their fault. Next frame, please. So clause 5, the duty of removal once aged 18. I just wanted to head that up and refer to it because it's important to recognise, as I think both Nicola and Kathryn have, that this sort of bright line of treating a person immediately they reach a child, as soon as they reach the age of 18, as being a fully fledged adult able to cope with removal is obviously a total fiction. Again, the family courts recognise that, and indeed the Court of Appeal has on occasion recognised that. The next slide, please. Okay, so this is the key part of the provisions that I'm going to take you to. It's clauses 29 to 36, dealing with the question of lost residence rights and citizenship rights. Next slide, please. First of all, clause 29. The impact of clause 29 is general, but it also relates to children. So it inserts a new section 8AA into the Immigration Act 1971 of persons ineligible for leave to enter and remain, entry clearance and electronic travel arrangements. So under that proposed section 8AA, a person who has ever met the 4 conditions set out in clause 2, or who falls into the definition of family members for the purposes of removal family members in clause 8, must not be given leave to enter or leave to remain, subject to proposed subsections 3 to 5. So that means that if they can't be removed, they will be subject indefinitely to the hostile environment, which means more people stuck, destitute, and with no plan for their regularisation of their status, even if they can't be removed. You would think, wouldn't you, by now that the Home Office understands that there's no necessary coincidence between the numbers of people that arrive and the numbers of people that can be removed, but it seems that they never seem to learn that. Okay, so as defined in clause 8, family members includes the person's children and any child living in the same household as P in circumstances where P has care of the child. So a broad interpretation of children who may be caught by P coming within the full conditions set out in clause 2. Next slide, please. So what are the proposed safeguards? Well, the provision of limited leave to remain for unaccompanied children and also for victims of slavery or human trafficking. An unaccompanied child may therefore be given limited leave to remain, but this may not be renewed once the child turns 18. And importantly, limited leave given under this exception cannot be taken into account for the purposes of determining whether the fourth condition under clause 2 is met. Next slide, please. And what about when a child turns 18? What does clause 29 have to say about that? Once an unaccompanied child turns 18, they must not be given leave to enter or leave to remain, subject to the proposed subsections 3 to 5. And I've set these out compendiously so that you can see how the different subsections affect the grants of specific types of leave. So the Secretary of State may give limited leave to remain where she considers that it's necessary to comply with the ECHR or another international agreement. I don't think we can be talking about unincorporated international instruments by that. What they're talking about is if at some stage in the future they decide that they do want to engage with negotiations with other nations about properly negotiated agreements on return. That might happen, and if it does, that's what the statute covers. Or that there are compelling circumstances in relation to the person, which means it's appropriate to do so. Now, I've starred she considers there because it's important to have a look at that, because what that does is insert a subjective test into the question that the Secretary of State poses herself, and on the question of necessity. And then the what's to be thought about there is the necessary impact that will have on accessing a remedy or the jurisdiction of the courts. Is it going to be viewed through the prism only of the Secretary of State's reasonableness? Obviously, the Secretary of State having a wide margin. And the problem with that is that it would appear to set up quite an obvious head-on clash with Section 6 of the Human Rights Act, because of course we all know that courts determining issues relating to the Human Rights Act have to determine for themselves not only the material facts but also the legal questions and the questions of mixed fact and law which arise in the context of interference and breach. So question there about what can be done to ameliorate the quite worryingly subjective questions that the Secretary of State will be able to ask herself. And then we've got, and the courts on review, obviously. And then on the question of indefinite leave to remain, again, where she considers it's necessary to comply with the ECHR or any other international agreement, note that there's no compelling circumstances provision in respect of indefinite leave to remain. The Secretary of State has said in numerous cases that what form of leave you get isn't a question that engages Article 8. Indeed, that's something she repeats in her memorandum dealing with compatibility. And then lastly, where a person has been removed and is outside the UK, Secretary of State may grant limited leave to enter or grant entry clearance or grant an ETA where she considers that it's necessary to comply with the ECHR or another international agreement, or that there are compelling circumstances, which means it's appropriate to do so. What the Secretary of State says about this provision is that the removal provisions are not in breach of Article 8 because you can always apply for entry clearance under this this clause of the bill, and therefore the ability to do that is what saves those removal provisions from having a head-on clash with Article 8. Isn't that great? Next slide, please. Thank you very much. So I've just set out there briefly what the Secretary of State's position is on the compatibility of Clause 29. What the Secretary of State says about settlement is repeated there at the bottom of the provision. I think it right to say that there are some quite complex questions about regularisation of status and granting of settlement, but I think that the case law certainly recognises that there may be circumstances in which Article 8 does compel a grant of indefinite leave to remain. Next slide, please. Then we go on to moving on to the permanent barriers to citizenship. So a person, including a child who is an ineligible person within the meaning of the Act, of the bill, sorry, so that's is not entitled, and it's clause 31 that provides this, who is an ineligible person. Once again, it's ineligible to be registered as a British citizen, a British overseas territory citizen, a British overseas citizen, or a British subject. And so it also applies to unaccompanied children and children arriving with family members. So who is ineligible? These are the two categories. Firstly, a person falls within this subsection, that is to say they are ineligible for citizenship, if the person has met the 4 conditions, or, and this absolutely blew my mind when I read this, a person falls within this subsection if P was born in the United Kingdom after the 7th of March 2023, and either of P's parents has ever, whether before or after birth, met the 4 conditions in section 2. I've called this the sins of the fathers clause. I don't know what you might think of that. There are some modifications in the following subclauses which extend the breaches in clause 2 to overseas territories. That basically means that if you've failed to get previous leave to remain or breached immigration controls in British overseas territories, the same impact will befall you in the context of any citizenship application you might make. Next slide, please. So children caught by, I've only picked out the children's provisions here, but and we all, of course, children do grow up, so obviously they'll be affected in perpetuity for any naturalisation application they might make too. But it's important to note here that children caught by clause 30, 3 or 4, that's the 2 categories I just took you to a minute ago, will lose the following rights to registration. So it's entitlement to registration they will lose, subject to the payment of a fee, of course. Section 1, 3 and 4 of the British Nationality Act, a registration as a minor. Section 3, 2 or 5 of the BNA, acquisition of British citizenship by registration minors. And section 4.2, that relates to British overseas territories, and section 5, Gibraltar. All of those entitlements lost. Next slide, please. In relation, there's also, and importantly, the loss of discretionary registration. I genuinely cannot see how that's compatible with section 55, but anyway, but I expect somebody will have come up with a last minute amendment to disapply section 55. But in any event, in relation to an application for British citizenship made in relation to an ineligible person, the Secretary of State may not cause the person to be registered as a British citizen under the following provisions. Section 3.1, that's discretionary registration of minors in their best interests. And we know that the intention was to sort of protect the rights of children who are may not be entitled to citizenship, but nevertheless their particular circumstances demonstrate that they have their future lies in the UK, and they have ties to the UK. They put down roots in the UK. In the future, those children, no matter how hard they've worked, how many A levels they've got, they won't be getting citizenship according to this provision. I don't know how helpful that is for society in general. I certainly don't see necessarily that it's going to be a net benefit, because I cannot, for the life of me, extrapolate from that any understanding that somebody coming for safety in a small boat might be able to perceive, which might influence their thinking in taking that dangerous course to safety. And then, of course, they can't be registered either under Section 4A of the Act. And of course, you know, the other discretionary routes to citizenship, such as naturalisation, once a child becomes an adult, if their parents have been satisfied the 4 conditions, then they will be excluded from that, no matter how upstanding they are as a person. Next slide, please. So there are some exceptions here. Again, they relate to the Human Rights Convention or other international agreement, but as the Secretary of State's memorandum makes clear, they don't think that grants of citizenship, which of course we must all remember is a privilege, not a right, relate to any human rights in any event. So that's the argument there. Next page, please. I've got some observations. I have to say, I mean, this is full of absolutely nasty stuff, this piece of legislation, which I'm very much hoping that clause 33 and 4 are what Linton Crosby described as a dead cat, where everybody looks at that and then some other stuff gets through. That would be good if we could just get rid of it quickly. And I've set out there again what we remember is going to be the long-lasting effect. I mean, this is going to go on and set out a time bomb of a whole cohort of young people who are denied citizenship and disaffected. I wonder how British that encourages them to feel when they're being levelled up in their communities. Please discuss. Answers on the postcard. And this provision obviously doesn't contain much by way of safeguards, given the government's position on Article 8. I've made a reference there to an old case of, not so old, I suppose, of Mr. Justice Ousley's, where he deprecated the logic of denying citizenship to children on the basis of what they wanted, of what their parents had done. I deprecate it too, and that's all I have to say. Thanks very much.
Thank you. Thanks, Amanda. Right. We've got a couple of questions. So the first question is to Ollie. I'll read that out, Ollie, and then are you okay to answer on that?
Is this Nina's question?
Yeah.
I've answered it in the chat. If that's
Okay. Okay. That's fine. So then we also have we've got a question about discrimination, and then we've also got one on from Cynthia. Thanks to all, utterly depressing, but thanks. Amanda, can you see this question?
Oh, where is it?
So Amanda, could you say anything about stateless children born in the UK? Schedule 2 para 3 is not included under 31. I think the bill would affect them adversely if a parent falls foul of clause 2. Could be removed.
Unless there's no protection for stateless children in there.
Okay, and then there's someone's asked, when the Australian government first began bleating about boats and introduced legislation treating people arriving this way differently to those arriving equally without prior leave to enter by other means, there was an argument made, I can't recall whether it was ever the basis of a legal challenge, that this approach amounted to result in indirect discrimination, given the clear trends that could be shown in the nationalities of asylum seekers arriving by different modes. Has this argument been considered in the UK context? Well, as far as I'm aware, it hasn't been, I mean, certainly hasn't been considered by the courts. And in terms of the discrimination that arises, I think certainly in what we see with the treatment of children, nationalities, in their other status in arriving, and I mean, there's also a question of disabilities, that there's certainly arguments that arise from it. Does anyone else want to say anything on that? No.
Can I come back to Cynthia? I mean, I can't extrapolate from the exceptions that are in clause, I think it's 35, anything which protects children from who would otherwise be stateless. But it may be that you could make an Article 8 type argument arising from statelessness, and it may be that you could persuade the government that being a signatory to the UN 1954 Convention on the Reduction of Statelessness would be would be sufficient. I mean, I think it's more there's a lacuna there. And I guess, Cynthia, you're going to be very well placed to lobby in respect of that cohort of particularly vulnerable children.
Thank you. The reason I suddenly smiled was because I saw another question from Nick Heslop. What would happen if at 18 the unaccompanied child is playing for Man United? Yeah, and what would happen if we got Gary Lineker on board?
Yeah, so compelling circumstances for limited leave, but no compelling circumstances for, and anyway, compelling circumstances relating to the person. You are a football player. Yeah, limited leave, but no ILR, I think is what you get out of there. If you were the Nobel Prize winning footballing cancer curing migrant whose father's fallen foul of the 4 conditions.
I can't see any other questions. It's actually quite nice in a way to end these 3 webinars that are just, discussing provisions that are so shocking and violating, to end on the note of the Man United player. So with that, thank you all very much for joining us, and thank you to all our brilliant speakers. And I'm now going to close this webinar. Thank you all.